Good day, everyone. My name is Victor Ayoola. I am a 300 level student of the Faculty of Law, University of Ibadan, and I am also an intern at HARLEM Telecoms Academy. Today, I'll be giving a video lecture on an overview of right to privacy in the lawful interception of communications in the telecommunication sector in Nigeria. However, before I talk about lawful interception and right to privacy, I would like to give a scenario to aid our understanding of the subject matter. Now, I am currently in Ibadan and I make use of MTN as my major telecommunication service provider. And I also have a friend in Abuja who also makes use of MTN. And then I called him on phone and then we discussed about some private information which I really do not want any other person to know. Now, making use of MTN as a service provider, the question then pops up: does MTN actually have access to our private communications? Generally, the answer is no. However, they have what we call CDR. CDR is an abbreviation for Call Detail Record, which contains specific details about the call, like my location, the location of my friend, and details like the time I spent on call with this friend of mine. Now, what then is lawful interception of communication? Lawful interception of communication is the official authority a service provider has in the telecommunication sector to have official access to private communications of its subscribers. Now, the question an average Nigerian would ask is this not a breach of my right to privacy? Well, it is true that Section 37 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, provide for the right to private and family life, which also protects telegraphic communications and correspondence. However, this right is not absolute, it is qualified. As such, Section 45 of this same Constitution provide for instances where these rights can be derogated, that is, in instance of national defense, public safety, public morality, and public order. Now, it is based on these grounds that the NCA 2003 has made provisions for situations or conditions where lawful interception of communications is allowed or where interception of communications is considered legal or lawful. Now, I made mention of NCA 2003. What is NCA 2003? NCA 2003 is an abbreviation for Nigerian Communications Act of 2003, which is the major legal framework for telecommunication service in Nigeria. This NCA 2003 also establishes the NCC, which is the Nigerian Communications Commission, which is the body or commission that makes sure that telecommunication service providers and internet service providers actually comply with the provisions of NCA 2003. Now, Section 147 of this NCA 2003 provides that the NCC shall have the power to give technical requirements to its licensee to carry out lawful interception of communication. Moving further, Section 148, subsection 1c provides that in situations of public safety and in situations of emergency, the NCC can lawfully intercept private communications of individuals without any court order. This then raises the question: does this house the jurisdiction of the court? No. Under Section 4, subsection 8 of the Constitution of the Federal Republic of Nigeria, it makes provision that no act of the National Assembly shall have the jurisdiction of the court. Hence, any action of the NCC can be brought before the court to determine whether it is valid, legal, or justifiable. Moving further, Section 70 of the NCA 2003 also empowers the NCC to make regulations and guidelines. And one of the regulations they have made is the Lawful Interception of Communications Regulation 2019, which is now considered as the legal framework for interception of communications in Nigeria. Now, Regulation 4 of the Lawful Interception of Communications Regulation 2019 makes provision that authorized agencies mentioned in Regulation 12, paragraph 1 shall have the legal right to actually intercept communications of persons making use of telecommunication services of any of their licensee, whether within or outside Nigeria. So, for instance, let's assume that I have a friend that is in America that is making use of MTN, that is still making use of MTN. Because MTN is licensed in Nigeria, if the situation warrants such, the authorized agency can actually intercept such communications of the person, even though the person is outside the country. Also, Regulation 8 of this Lawful Interception of Communication Regulation 2019 provide for situations in which communications of individuals can be recorded. One, when one of the parties has showed consent and there is proof. Two, when one of the parties believes that there is a threat to his human or life safety. And three, where such recording is actually required in the ordinary course of business. Now, earlier mentioned, I stated that Article Regulation 4 provides that all authorized agencies shall have the legal right for interception of communications in Nigeria. Now, these authorized agencies have been listed in Regulation 12, Paragraph 1, stating the Office of the National Security Advisor and Office of the State Security Service. Importantly, Regulation 12, Paragraph 4 also provides for conditions or circumstances where these authorized agencies can actually lawfully intercept communications in Nigeria without any need for warrant. One, where there is a threat of national safety. Two, where there is a danger of death or serious harm to a living person. And three, where there is a threat of activities of an organized crime. So in a situation in which I was discussing with my friend, let's assume that we were talking about how to launch a terrorist attack in Abuja. Such will constitute as a threat to national safety, and as such, the authorized agency in such instance, without no need for warrants, can intercept our private communications. Lastly, it is not only the Constitution, it is not only the NC 2003, and it is not only the Lawful Interception of Communication Regulation 2019 that are the only laws that regulate interception of communications in Nigeria. We also have the Terrorism Prevention Amendment Act of 2013 and the Cyber Crimes Act of 2015. I hope you have been able to learn one or two things about your right to privacy in the telecommunication sector. Thank you for listening.